Bom dia a todos. Nós damos início agora ao nosso evento no Instituto LGPD. O evento será em inglês e posteriormente nós colocaremos, então, uma legenda. E agora, então, eu já vou mudar em respeito também ao nosso palestrante para o inglês. Good morning, everyone in Brazil. First of all, I'd like to welcome Professor Martin Eifert, the debaters, Patrícia Campos Mello, Laura Moraes, João Brandt, Pablo Ortellado, and last but not least, the audience of our institute on YouTube. Before I forget, subscribe to the channel if you haven't done already to follow the public content we produce here. So with this event, the Legal Grounds Institute opened a new work front focused on promoting national public debate, bringing the main authorities and experts on issues related to the digital services regulation initiatives from other countries and continents. The Institute's initiative seeks to achieve two main goals. First, to avoid disproportionate regulation that restrict the rights and individual guarantees. And at the same time, we try to bring the national debate closer to the best global practice on this subject. The idea of inviting Professor Martin Eifert to the opening of the Institute's International Observatory on Digital Regulation has two main justifications. The first one is for Professor Martin Eifert's expertise as a renowned expert on subject and a consultant of the German government on this subject. Professor Eifert was recently chosen by the German Ministry of Justice to prepare a report on the 3 years of the famous German law on social network regulation, Netzwerkdurchsetzungsgesetz. The second justification of inviting Professor Martin Eifert lies on the fact that it's important to realize that the debate around the increasing liability or the increasing debate on the liability of the internet intermediaries is a global movement, given the importance that digital services have in daily lives of the population and of the economy, of course. We will have several other events that will follow this one. So that's the opening event of the International Observatory. So I wouldn't like to take up any more of presenters and debaters' precious time, and I will hand the floor immediately to Professor Eifert. Thank you.
Thank you very much, Ricardo Campos, for this very kind invitation and introduction. It's a great pleasure and a great honor for me to give today's lecture on the responsibility of online intermediaries, more precisely on social media. Maybe we can get the first slide, because I think at least for those who are not familiar with the regulation in Europe or in Germany, it might be very helpful to have some kind of visual support. I'll make a general introduction first anyway. Social media is extremely important, as we all know, for individual self-realization as well as for community building and public deliberation. Its regulation has got into the focus of legislators all over the world, and it is intensely discussed among politicians and academics. Until recently, social media was typically covered by a broad liability shield for all internet intermediaries, which had been enacted decades ago in the EU, the US, and elsewhere. The liability shields reflected the predominant notion to avoid anything that could stifle innovation at the dawn of promising new internet services. In the meantime, however, social media has gained tremendous significance in social life and its economic particularities has left only very few and powerful providers. Social media's impact and its market structure have fundamentally changed the way we think about its responsibilities. Two developments are driving the discussion. Firstly, social media not only fosters public discourse by sidestepping established mass media gatekeepers, it also enables users to disseminate hate speech, misinformation, and all kinds of illegal content. The reach and dynamics of platforms amplify the harm resulting from it. As a consequence, the focus has shifted from liability exemptions to designing an adequate scheme of due diligence obligations. The major challenge for any approach to this problem is to prevent harm on the one side without having chilling effect on free speech or stimulating overblocking by platform operators on the other side. This regulatory challenge obviously implies difficult human rights questions. Secondly, social media do not only sidestep traditional mass media gatekeepers, they have become gatekeepers themselves. Their terms and conditions and algorithms define what can be said and heard, and their power to remove content and to block users has significant influence on public discourse. Many of us are concerned because we do not want private companies to exclude important controversial issues from public deliberation. Again, difficult human rights issues are raised. To what extent are the platforms free to set standards as they like as part of their business model? And to what extent are they required to take the right to freedom of expression of their users into consideration? Before starting our exploration of the regulatory issues, we should make sure that we have a shared notion of the situation we are talking about. Therefore, I will first of all have a closer look at social media communication and the problems entailed with it. Afterwards, we will roughly summarize the path legislators in Europe have taken in order to address at least some of these problems before we turn to the different issues and the respective regulatory approaches in more detail. We will focus on three topics, starting with illegal content and the responsibilities related to it. Then we will examine questions of private content moderation beyond such illegal content. Eventually, we will ask how to adequately deal with systemic risks for liberal democracies that may result from effects like echo chambers or content which is not illegal but nevertheless harmful. We will see that a common thread running through all legislation is the approach to set a framework for self-regulation, leaving the operators the more leverage, the more the issues are free speech sensitive. Procedural and organizational requirements are the core of social media regulation. Let us start with a brief description of the phenomenon and the problems we are facing. On the next slide, we will see the setting. Social media have blurred the line between mass communication and individual communication. They've created a network of users that are generating and consuming content on social media platforms, which in turn allow for easy access and high connectivity. For analytical purposes, it's helpful to focus on the triangular structure which is underlying the platform communications. We have a great number of users, all of whom can produce and consume content, but in each single act of communications, every user is either sender or recipient of content. The social media platform is providing the infrastructure for all communications. It enables users to communicate online by providing easy access, making available tools for producing content, and generating opportunities to connect with other users. As social media foster content generation and connectivity, they also amplify all effects of user content. The easily accessible infrastructure has created a space for communication that contains an unprecedented amount of speech. Additionally, persistence, reach, and dynamics of online speech allow for far-reaching effects. Online content is available without time limit, can reach an unlimited number of recipients, and takes part in the dynamics of online communication. We all know phenomena like shitstorms or content going viral. If this is the setting, what's the problem? The first problem is that the unprecedented amount of speech also contains an unprecedented amount of harmful speech, and that social media also amplify the harm entailed with it. The most obvious harm is infringement of private rights or violation of laws which also protect public interests, in other words, illegal content. The second problem is closely linked to the market structure. Control and curation exercised by social media operators become a problem if there are only very few of them. The more public deliberation takes place on these very few social media platforms, the more influential are decisions of social media operators about content and information flows on the platform. Economic market power turns into impact on public discourse. Thirdly, we are concerned about more indirect systemic effects. Speech which is not illegal, such as disparaging messages which do not qualify as defamation or fake news, can nevertheless be used to intimidate vulnerable groups, to erode trust in government institutions, to disparage groups, opinions, office holders, or signs. Even though the single act of communications is not illegal and should not be illegal as it does not result in immediate harm, the sum and dynamics of such communications can nevertheless result in serious harm. This is especially the case if certain patterns apply. The amount of such speech can be enhanced by fake accounts or bots and surpass any capacity of public discourse to make effective corrections. The emergence of communities which echo such communications over and over again can foster radicalization. And the systematic targeting of individuals or vulnerable groups with such speech can silence their voices. In short, such speech, all the more if combined with illegal speech, may undermine preconditions of public deliberation and democratic governance. This is a systemic effect. The regulatory issues, of course, reflect the problems I've just mentioned. Maybe we can switch to the next slide. It is first of all private users, not the platforms, who infringe private rights. But it is difficult and often impossible for aggrieved parties to gain redress from the primary infringer, especially because his or her name and address is in most cases not known by the aggrieved party. This spotlights the responsibility of platforms for illegal user content. They are a secondary infringer as they contribute to the harm by disseminating the illegal content. The regulatory question is if or to what extent they should be required to use their control over content on the platform to prevent dissemination of illegal content. In other words, we are talking about content moderation by social media operators, which is legally imposed. The second problem relates to another prong of content moderation, the one which is based on so-called community standards and exercised by platforms irrespective of any legal framework. Community standards are embodied in general terms and conditions of the contracts between social media operators and their users. They define inter alia which content must not be uploaded. Platforms are enforcing the terms and conditions by removing content or even by blocking accounts in case of violations of the community standards. It is important to notice that the scope of the community standards is overlapping with the legal order of the states, but is not fully consistent with it. Some social media, such as Facebook, include a clause which forbids to upload illegal content, but the clause is accompanied by its own set of restrictions. Other platforms do not have any reference to state law. Divergence between the legal order and community standards results mainly from two factors and their complex interplay. Firstly, a legal culture in social media that is still very much rooted in US notions of free speech. And secondly, the incentive structure which fosters a design that makes all users feel as comfortable as possible. Whatsoever the diverging area between legal content and community standards precisely looks like, this is the area in which private power, namely the power of social media operators, is constraining speech. The regulatory issue is whether or to what extent social media operators are free and should be free to set community standards as they wish. The private power, however, is ambivalent. Some people call it private censorship, as private companies prevent the dissemination of legal content. From this perspective, the community standards withdraw content from public deliberation, and they prevent a robust public discourse without having sufficient legitimacy to do so. On the other hand, private content moderation is seen as an appropriate means to regulate harmful speech, which, for reasons of constitutional protection of free speech, could not be regulated by the state. This is particularly the case with regard to the problem of systemic effects of some kinds of speech, such as not prohibited variations of hate speech. Let us conclude our first overview by briefly introducing the fundamental rights perspective on the problems and regulatory questions. It goes without saying that any government regulation of social media must be aware of the fundamental rights of social media operators. It is also obvious that it must be aware of negative effects on free speech. Regardless of how it is framed in constitutional doctrine, government regulation must not inhibit free speech unless the restrictions serve a legitimate goal and are tailored in a proportionate manner. German as well as European constitutional law acknowledge the fundamental character of free speech for any liberal democracy and emphasize the sensitivity of free speech to detrimental effects. Therefore, traditional doctrines make it very difficult to outweigh free speech in the balancing test. Law of defamation and other forms of illegal content are recognized limitations of free speech, but any enforcement by government or through legally designed mechanisms shall not have a chilling effect. If we apply the chilling effect doctrine to social media regulation, it certainly means that any approach should be eager to avoid incentives for overblocking of user content. Potential infringements of private rights or committed criminal offenses like incitement to racial hatred by user-generated content are on the opposite side of the scale, and they are limiting the right to freedom of expression. In face of the amplification of harm resulting from reach and dynamics of social media interaction, we should not just apply traditional doctrinal rules, but we need to reconsider the balance between freedom of expression and such private and public interests. When asking for the appropriate balance, we should also consider potentially existing constitutional obligations to protect such interests. I hope we have now a shared notion of the phenomenon and the problems we are talking about. Let us turn to the answers which have been given thus far by the European legislators. I will start by giving you an overview of the developments so that you can get an impression of the general approach and the momentum of European legislation before describing in more detail the approaches to each of the problems which we have identified. On the next slide, you can see the development of the European legislative framework in the member states. From the outset of any specific regulation of intermediary services, limitations of liability have been a prominent feature. At the dawn of internet services, as I just mentioned at the beginning, liability privileges were almost all regulation that was enacted. Legislators worried that liability could stifle innovation and were eager to facilitate the fast development of services such as social media platforms, a goal shared among other regulations by the famous Section 230 Communications Decency Act in the US, and for all purposes more important, Articles 14 and 15 of the e-commerce directive in the European Union. All liability exemptions, however, fell short of excluding all kinds of liability. While any general obligation to monitor user-generated content stored or transmitted is explicitly ruled out by Article 15 e-commerce directive, the liability exemption for user-generated content in Article 14 e-commerce directive is conditioned. More precisely, it is conditioned on expeditious removal of illegal content upon obtaining actual knowledge of it. From the perspective of aggrieved parties, this boils down to injunctive relief after notice, but no compensation for any damage occurred. I put so much emphasis on the liability exemptions because, as a general rule, they've been upheld in any general European regulation since then. At first glance, this is surprising because at least the nowadays dominant platforms definitely do not need an innovation waiver anymore. Another justification for this approach is still valid though. Social media communications is done at scale. We are talking about billions of user-generated items per day on the big platforms such as Facebook or Twitter. Considering the sheer amount of speech, monitoring requires automatic means. Automatic means, at least by now, cannot handle many of the context-sensitive evaluations that determine, for instance, defamatory speech. If monitoring had to be made by human beings, however, it would become very costly, if not impossible. Therefore, a due diligence obligation to monitor all content would render the business unprofitable or even unfeasible. It would be the end of the internet as we know it. In other words, the liability limitation lives on as a result of a proportionality test. The fundamental right of providers to conduct business is constrained by liability rules, and a liability regime which does not condition liability upon knowledge or awareness of a specific illegal content would not be proportionate, as it would in fact shut down the operators. And after all, platforms only facilitate and amplify the harmful activities of their users and do not commit the wrongs themselves. Notwithstanding the persisting justification for limited liability, a need for increased responsibility of social media has become evident. The e-commerce directive, enacted as early as 2000, could not cope with the problems that were emerging as social media became more and more important and powerful. As a first step, national governments such as the German government as well as the European Commission started a dialogue with the powerful social media operators in order to stimulate voluntary action against pressing issues. Especially hate speech had become a very pressing issue in times of intense discussion about migration politics. Even though there was some improvement on the side of at least some major social media, the overall results were not satisfying. Consequently, the German government, additionally fueled by an election campaign, introduced the Network Enforcement Act, which entered into force in 2017 after a fierce debate. The basic elements of the Network Enforcement Act have heavily influenced all European regulatory efforts ever since and are worth being described. The core element are procedural and organizational obligations for operators of social media platforms, which comprise three requirements. Firstly, an easily accessible procedure to give notice about illegal content. Secondly, a proper evaluation of incriminated content. And thirdly, timely removal of illegal content within at least 7 days, or in case of manifestly illegal content within 24 hours. The evaluation of the content can be done by the operator itself, or it can be handed over to a recognized independent self-regulation institution. Compliance with the statutory requirements is enforced by public administration, and violations could lead to regulatory fines. Apart from requiring a compliance system, the Network Enforcement Act imposes rather detailed transparency obligations on social media operators. They have to report and publish biannually about the amount and types of unlawful content on their platforms, as well as about their measures in handling it. Having roughly described the content, it is also important to underline what the Network Enforcement Act deliberately does not regulate. It refrains from establishing a liability system and instead builds on the existing liability of media platforms for interference as a transmitter of illegal content. The legal consequence of this liability is always removal of illegal content, not compensation for damages. It is also noteworthy that the Network Enforcement Act applies only to large networks that have more than 2 million registered users in Germany, and that it addresses only some illegal content, namely already existing criminal offenses which are listed in the Act. Not surprisingly, the discussion about the Act has continued in politics and academia. The paramount issue were and still are free speech concerns. Many commentators argue that the time limit, combined with the public enforcement and fines in case of violations, is a strong incentive for operators to remove content if in doubt about its legality, so that the regulatory framework results in overblocking. This argument, however, does not adequately reflect the legal framework. It can be argued, and I personally share this point of view, that the requirements on complaint handling comprise all aspects of proper evaluation, and that underblocking is as much subject to potential fines as it is overblocking. On this assumption, the incentive structure would be balanced with regard to any decision about removal. Furthermore, fines can't be based on misjudgments on individual cases of content evaluation. Fining requires systematic failure in content evaluation and a respective court decision on the misjudgments, so that any individual judgment is unburdened. In 2020, we've conducted an evaluation of the Act, and we could not find any evidence or indication for overblocking. Nevertheless, free speech is such a vulnerable value that it is easy to make a case for an improvement of safeguards. Reflecting the ongoing discussion, amendments to the Network Enforcement Act have been introduced in Parliament and will probably be enacted very soon. The most important amendments from the perspective of our topic are the following. Operators will be required to give reasons for their decisions upon removal of incriminated content, and either party shall be given the opportunity to object to the decision and to require its re-evaluation. Additionally, independent out-of-court disputes resolution panels will be set up and will decide on re-evaluation decision on condition that both parties agree. The German Network Enforcement Act is the most prominent regulation in Europe and the only one which is enforced right now. France enacted a similar law in May 2020 called Loi Avia, but it was invalidated by the French Constitutional Court, the Conseil Constitutionnel, just 1 month later. One major reason for the invalidation was the fact that according to this statute, operators had to decide within 24 hours with respect to some illegal content, and that they could be fined on the basis of not removing a single item of content despite its illegality. It's quite obvious that this was a strong incentive for overblocking. Austria has drafted a law on social media platforms, the so-called Kommunikationsplattformgesetz, which is very much along the lines of the NetzDG, the Network Enforcement Act in Germany, and which has already passed the notification procedure with the European Union. Against the backdrop of the just described increasing activity among the member states, an obviously outdated European regulatory framework, and the ambitions of its digital single market strategy, the European Union Commission presented its proposal for legislative package just 5 months ago. We will see it on the next slide. It consists of the Digital Market Act and the Digital Services Act. The DMA, the Digital Markets Act, focuses on economic power of internet platforms, whereas the Digital Services Act, DSA, focuses on the mitigation of externalities resulting from illegal content, together with the protection of the public interest in an open and free public discourse. By and large, the DSA resembles the approach taken by the German Network Enforcement Act, but modifies it in important aspects. At the outset, the DSA confirms the general limitations on the liability of internet service providers known from the e-commerce directive. The vast majority of its provisions, however, set up a regulatory framework with a special focus on so-called online platforms, which include social media platforms. Such online platforms are subject to procedural and organizational requirements, which, first of all, aim to ensure an effective notice and action mechanism for illegal content. The DSA does not only require a decision on the incriminated content in a timely, diligent, and objective manner, including a statement of reasons, but it also sets up a two-step complaint handling system. The latter starts with an internal review procedure and provides for an obligatory subsequent out-of-court dispute settlement mechanism. Very large platforms, which have at least 45 million active recipients in the EU, also need to engage in an assessment of systemic risks stemming from their services and have to undergo independent audits. In addition to the elaborated complaint handling procedures, the DSA establishes various transparency obligations for social media platforms, many of which relate to content regulation and risks for the public interest. Transparency obligations comprise the duty to include information on content restrictions imposed by the terms and conditions, and also reporting requirements about the means and measures of content moderation. Finally, the DSA introduces public enforcement of the regulation, including the power of public authorities to impose penalties such as fines. As a result of limited competences of the EU regarding the law of torts and criminal law, the DSA lacks genuinely European liability rules and any definition of what constitutes illegal content, but instead simply refers to the law of the member states. Such strictly formal and uniform definition of illegal content forecloses the possibility to define especially harmful illegal content to be controlled, and it forecloses any kind of priority setting when it comes to removal. In sum, compared to the Network Enforcement Act, we can observe an even more elaborate system of decision-making on incriminated content, the emergence of some rules on terms and conditions, and the adoption of public enforcement. However, we do not have specified time limits for removal. The brief survey has shown that Europe has entered a path towards increased responsibility of social media operators. The crucial element is a notice and action mechanism which is embedded in a system of review procedures. The legislative means are procedural and organizational requirements which set up and design such system in a way that protects free speech and avoids overblocking. We've also observed first and very cautious regulatory steps which address the terms and conditions of social media operators and some measures which help to clear up potential systemic effects. Having mapped the path, it is time for an exploration of some crucial questions. We can go to the next slide. The attempt to hold platforms accountable for user-generated content turns out to be anything but trivial. Notice and take action is a convincing approach, but if it is not more precisely designed by law, it provides a very strong incentive for operators to avoid getting any knowledge in order to avoid any liability. Not surprisingly, legislators have made significant efforts to make notice and take down work. The German Network Enforcement Act, as well as the Austrian Law on Communications Platforms and the proposed European DSA, require social media platforms to provide mechanisms which allow to notify them on specific harmful content on the platform. These mechanisms shall be easily recognizable, easy to access, and user-friendly. In addition, the DSA proposal introduces so-called trusted flaggers, a status which can be awarded upon application to entities which have special expertise, represent collective interests, and carry out their activity for the purpose of submitting notices. The notices of such trusted flaggers need to be preceded with priority and without any delay by the platforms. With regard to such notification requirements, the experience in the last years in Germany has shown that close monitoring is necessary to ensure the implementation. The requirements of the German Network Enforcement Act will be further specified in the amendments that are coming, and it remains to be seen whether the DSA regulation and maybe some specifications and codes of conduct will be sufficient to achieve the goals. The crucial element of notice and takedown is, of course, the evaluation of the content which has been brought to the attention of the platforms. Regulations require an, quote, effective and transparent procedure, quote, so the German Network Enforcement Act, or a decision in a, quote, timely, diligent, and objective manner, quote, the DSA proposal. Given the uncountable varieties of content, it is clear that there can hardly be more precise regulations on the decision as such. Once again, procedural safeguards are the most promising approach to ensure proper decisions. 4 aspects should be mentioned. First, in face of the amount of content, automatic means are unavoidable, even though they cannot be sufficient. The regulations ensure transparency about the fact that such means are used, but they do not address the algorithms as such. However, the more general discussion on accountable AI should also lead to more specific regulations in this field. Second, evaluation of context depends heavily on legal and cultural expertise in the field of media. Social media are operated by tech firms, which have such knowledge only to a very limited extent. Regulation needs to ensure that they acquire adequate expertise. Current approaches are using indirect ways, such as making the internal procedures subject to reporting and requiring a statement of reasons, which is to be communicated also to the user who generated the content. An alternative way to ensure proper evaluation is setting up specialized entities which handle the notices for one or even many tech firms. This approach is also included in the Network Enforcement Act, which makes it possible to transfer content evaluation to an independent entity. The advantage of this alternative is independent review of content by experts. Its disadvantage is the fact that social media operators do not regard it as part of their own business, so that there is very little incentive to consider potential negative effects already in the development of the algorithms which shape the online environment. Finally, in many cases, evaluation of the content is context sensitive. The user who generated the content has presumably valuable information on this context. It has been discussed to make compulsory some participation of the user who generated the content. On the other hand, as a standard procedure, this would be cumbersome and time-consuming. In the end, we do not find such procedural requirements. Instead, the user has to be informed about the decision and its reasons so that he or she can file a complaint in case of unjustified removal. In other words, a complaint handling mechanism which allows for subsequent correction seems to become the standard as a safeguard against unjustified removal. Let us turn to those mechanisms. According to the DSA proposal, online platforms must offer an effective internal complaint handling system to the author of the incriminated content that must be easily accessible and user-friendly. The platform is bound to deal with the complaints of authors in a timely manner, and it must not rely exclusively on algorithms. Where the platform finds that the complaint is well-founded, it must reverse its decision and reinstate the incriminated content. In that case, the remedy that remains available to the aggrieved party is only recourse to a court of law. However, in the reverse scenario, that the platform dismisses the complaint and refuses to make the content available again, it must offer out-of-court dispute settlement to the author. The body conducting the out-of-court proceedings must meet basic requirements of neutrality, fairness, and expertise, which are familiar from the European Directive on alternative dispute resolution. It is striking that this DSA proposal has an asymmetric design. The complaint handling mechanism and the ADR procedure are only open to the author of the content or the owner of the account, respectively, and not to the party which is affected by a decision not to remove incriminated content. An aggrieved party, for instance, a victim of defamatory statements, cannot enter the complaint handling mechanism. It can only file a suit in a court of law, and as we all know, a reputation may be lost on the internet long before a public court even issues an interim order of protection. Obviously, the DSA mechanisms are designed to prevent overblocking, but do not care about underblocking. The redress mechanisms ensures control of any removal of content, but is not open for re-evaluation of any decision against removal. This is an imbalance which raises constitutional concerns. The decision of the platform whether or not a posting has violated the personality rights of another party depends on the application of legal norms which strike a balance between the author's freedom of expression and the third party's right to privacy. The decision whether to remove requires a weighing and balancing of conflicting fundamental rights, which are enshrined in the national constitution as well as at the European level. The procedural remedies provided by the DSA should reflect this substantive duty to weigh and to balance, and should provide access for both sides, the aggrieved party as well as the user who has generated content. The German Network Enforcement Act requires only a complaint handling system, but this system is open to both sides of the conflict. We can turn to the next slide and come to the question of private content moderation. The notice and takedown mechanism. We can come to the next slide. Thank you very much. The notice and takedown mechanism, first of all, is a legal remedy against infringements of private rights or other unlawful content. The German Network Enforcement Act is the first legislation in the field that had limited its procedural and organizational requirements on notices about specific unlawful acts. However, social media platforms have operated some kind of notice and takedown procedures for violations of community standards independent from such regulatory frameworks for a long time. As legal limitations of free speech and community standards overlap in many respects, the field of application of legally required procedures and such voluntary arrangements is also overlapping. The evaluation of the German Network Enforcement Act has demonstrated that parallel procedures entail difficult regulatory delineations, and it is obvious that users should have some easily accessible remedies not only against removal of content which is based on a contested violation of law, but also against removal of content which is based on a contested violation of community standards. Therefore, the amendments of the Network Enforcement Act and the proposed DSA rightly apply the just described complaint handling and out-of-order settlement mechanisms to all kinds of decision on the removal of content, irrespective of its legal basis. In other words, any removal based on the violation of community standards is also to be re-evaluated upon request. This provides safeguards against an abusive application of community standards by platforms. Additionally, the proposed DSA requires platforms to include information on any restrictions that they impose on user-generated content and any policies, procedures, measures, and tools used for content moderation in their terms and conditions, and to make the information also available to the public. However, there are no regulations at all concerning the substance of such standards. The review mechanisms cannot accomplish more than a proper application of given standards. The crucial question concerns the legitimate substance of such standards. Do they constrain public discourse in an inappropriate manner? The DSA promises in Article 1 to effectively protect the fundamental rights enshrined in the Charter. Is it an empty promise with regard to free speech? Let us start by analyzing the incentive structure. A social media platform, which is ultimately selling custom-tailored attention to the advertising industry, strives to maximize the number of users who are as active as long as possible in an online community, and community standards as well as content moderation and curation are used to foster an encouraging online environment. Standards will therefore depend on the attracted communities. They may prefer some kind of attention-grabbing content and exclude some kind of controversy-prone content, as it has been analyzed for content moderation tools in the past. In any event, they will probably differ from the scope of lawful speech. In principle, it is without doubt the right of any private provider of a service to define the terms and conditions under which the service can be used. This would not raise many concerns if there were plenty of platforms, so that each user could choose the terms and conditions he or she preferred. However, as we well know, there aren't many platforms. Economies of scale and network effects were strong incentives and drivers for fast growth and have resulted in only a few social media platforms dominating the market. Additionally, strong lock-in effects for the users hampered the contestability of the markets, making it difficult for any company to enter it. As a consequence, market power transforms into power to limit what can be said and heard in increasingly important spheres of public discourse. The deplatforming of individuals, for instance, former US President Trump, on grounds of violation of community standards is the most obvious example. In sum, The DSA promise is not self-fulfilling, and regulatory reluctance is questionable. If you think about regulation, we should bear in mind that we have to strike the balance between the fundamental right of the platform operators to conduct their business as they please on the one hand, and the rights to non-discrimination and to freedom of expression, including the public interest in an open public discourse on the other hand. Any regulation needs to be graded and sensitive to the respective importance of the platform for public discourse. Broadly speaking, operators should be able to use community standards as a means of product differentiation, but they should be prevented from discriminating users or content without legitimate reason. They should also be required to define the community standards the more according to the general laws, the more the service aims at becoming the overall online environment for its users, and the more important it becomes for public discourse. Facebook probably comes to mind when we look for an example for a network which is particularly walled garden with great impact on public discourse. An appropriate regulation will rather result in a broad clause which requires operators to draft the terms and conditions with due regard to the rights and legitimate interests of its users, and will probably not define precise conditions. This, however, is very familiar from traditional delineations between conflict and private rights, and it has become the characteristic feature inter alia of data protection law. Even if such regulatory requirements seem to be desirable, thus far there aren't any. For the moment, the only source for any influence on fundamental rights on the drafting of community standards can be the Constitution and the European Charter. This touches upon the tricky question of horizontal effects of fundamental rights on private transactions and more general on acts of private parties. While we have a long-standing doctrine on indirect effects of fundamental rights in private law at the national level in Germany, there is no broadly accepted doctrinal basis for extending the scope of the EU Charter to relations between private parties. Thus, its effect on the process of drafting terms and conditions that specify the requirements for removal and reinstatement of undesirable content remains an open question. It is plausible to assume, however, that the Union has a duty to protect all fundamental rights when setting rules for the online environment. And if the online environment is shaped by powerful private actors, it is also plausible to assume that the duty to protect may comprise making those private actors responsive to the fundamental rights that their business practices may affect. It is at least doubtful whether the broad discretion that the DSA leaves to online platforms with respect to their terms and conditions is consistent with the Charter. Arguably, it is not just desirable, but demanded to enact a statutory requirement which forces operators to draft the community standards with due regard to user right to freedom of expression. We have now touched liability for illegal content and legal restrictions for community standards. The most difficult regulatory question, however, is definitely how to deal with systemic effects. We'll come to the next slide. There are two major reasons for it. The first reason is that we have thus far very little knowledge about such systemic effects. The general notion that there are toxic effects for public discourse and an erosion of trust in public institutions is based on shocking events like the storming of the United States Capitol. However, it is not easy to distinguish between social media impact on the one hand and developments that have an interplay with it but are rooted outside the internet on the other hand. Is polarization resulting from social media communications, or is social media communications just a mirror? The second reason is that any regulation would go beyond any traditional limitations of free speech and would entail a great potential for abuse. The right to freedom of expression protects for good reasons speech which is annoying or irritating, and viewpoint neutrality is a general rule for limitations. The high degree of uncertainty concerning systemic risks has become a major driver for the quest for more transparency and further risk assessment. The DSA approach relies on knowledge generation and accountable self-regulation. The DSA imposes a duty on very large platforms to identify, analyze, and assess periodically any significant systemic risk stemming from the functioning and use made of their services in the EU. Following up to the risk assessment, the platforms have to put in place mitigation measures and to publish a report on risk assessment and measures taken. Besides, public authorities can request very large platforms to provide access to data to vetted researchers. Eventually, if significant systemic risks emerge and concern several large platforms, the Commission may invite the very large platforms and other stakeholders to draw up a code of conduct. Given the current state of uncertainty, this might be the best approach for the moment. In the long run, however, it can hardly be left to the platforms alone to define the degree of bearable risks and appropriate countermeasures. If you think about adequate means, however, they should be as transparent as possible and extremely cautious with regard to removal of content. Even though it is too early to determine any measures, three approaches appear to be at least plausible. Regulation could foster counter-speech for some kinds of content, such as fake news. It could slow down the specific dynamics of social media communications if patterns occur which proved typically as typical attacks to vulnerable groups. Or, last but not least, it could limit persistence of postings in order to avoid a harmful amount of toxic speech. All such approaches, however, need more insights and should be tailored very carefully. Systemic effects deserve much attention in the future, but the lecture has to end very soon. Instead of elaborating about the upcoming questions, let me make some concluding remarks. Responsibility of social media is highly ranked on the international agenda. Apart from an obvious abuse of the situation by authoritarian regimes, we observe a serious discussion among liberal democracies about future regulatory frameworks. All liberal democracies find themselves in a dilemma. They are based on free speech and yet find themselves increasingly threatened by speech. Government must not abridge free speech, but faces powerful platforms and private speech regulation, which may put open public discourse at risk. The emerging European way to deal with the dilemma is a graded system of co-regulation. Government imposes procedural and organizational obligations on the social networks, which ensure prompt removal of illegal content and proper evaluation of the underlying decision on the content. It will require an application of community standards which is sensitive to fundamental rights, and arguably it will also have to provide for an influence of fundamental rights on the substance of community standards. Finally, it aims at shedding more light on systemic effects by fostering risk assessment and independent research. To my mind, this is not bad for a beginning. I'm curious to get to know your perspective in the following discussion. Thank you very much for your attention.
Thank you, Professor Eifert, for your very much deep and rich lecture about the European and German parameters in the